The following is a list of alleged and confirmed assassinations reported to have been conducted by the State of Israel. It includes attempts on notable persons who were reported to have been specifically targeted by the various Israeli security, intelligence, and law enforcement agencies. According to Eyal Weizman, targeted assassinations have become the most significant and frequent form of Israeli military attack, and serve not only to contain terror but as a political tool to control Palestinian territories Israel has otherwise withdrawn from. In response to protests over the number of civilians killed in targeting operations, and the refusal of a number of pilots to engage in such missions in 2003, Israel set up groups to minimize collateral damage in 2003 to establish acceptable levels of damage to bystanders. In 2006, focused lethality munitions, missiles with intense but highly localized explosive were introduced to this end, and in November a legal committee was set up to rule on assassinations. The Supreme Court of Israel, in response to a suit on the practice, mainly regarded actions in the occupied Palestinian territories, ruled on December 14, 2006 that such actions took place in an international armed conflict but that the terrorists, as civilians, lacked combatant status under international law. Yet they were, in the court's view, civilians participating directly in hostilities, which would mean they lose their immunity. It also ruled, following a precedent set forth by the European Court of Human Rights in its McKen and others v. The United Kingdom judgment, that a law of proportionality, balancing military necessity with humanity, must apply. Assassination were permitted if strong and persuasive information concerning the target's identity existed, if the mission served to curtail terror, and if other techniques, such as attempting to arrest the target, would gravely endanger soldiers' lives. Nils Melzer in his 2006 study Targeted Killing in International Law defines targeted killings in terms of 5 criteria, summed up as the use of lethal force attributable to a subject of international law with the intent, premeditation, and deliberation to kill individually selected persons who are not in the physical custody of those targeting them. Before 2001 Israel denied it practiced or has a policy of conducting extrajudicial executions. The term itself gained widespread currency only after Israel went public concerning its policy regarding alleged terrorists in the Palestinian territories. Killings in the past were often premised on revenge for earlier crimes, and required a quasi-judicial commission to convict the target of culpability before action was taken. The policy, reintroduced by Ariel Sharon in the face of suicide bombings, no longer took evidence of potential involvement by the target in future attacks on Israel as decisive, and the decision was left to the discretion of the Prime Minister and Shin Bet. According to the former legal advisor to the State Department Judge Abraham Sofar, killings in self-defense are no more assassinations in international affairs than they are murders when undertaken by our police forces against domestic killers. Targeted killings in self-defense have been authoritatively determined by the federal government to fall outside the assassination prohibition. A state engaged in such activities must, however, Sofar concluded, openly acknowledge its responsibility and accept accountability for mistakes made. This characterization is criticized by many, including Amnesty International. B'Tselem has calculated that between 2002 and May 2008, at least 387 Palestinians died as a result of Israeli targeted killings, of which 234 were the targets, and the rest collateral casualties. The majority of Israeli targeted killings have taken place in Area A of the West Bank lying within the jurisdiction of the Palestinian National Authority. Gaza, according to Eyal Weizman, has now become the world's largest laboratory for airborne assassinations.